Yes, student, most importantly, let us deal with the difference between a charge sheet and an indictment. A charge sheet is that form that will be filled by the prosecutor at the district court. Because what is also very important, I gave you guys a question on what cases can be brought to the district court. It is important to note this, that half of the class did not know that each and every case, no matter how serious, has to be brought to the district court. There is no case that starts at, there is no criminal case, right? You must make the difference. Criminal case and civil cases. For criminal cases, all of them has to begin at the district court. I hope you've got that in your head. For each and every criminal court, the first court of instance will be the district court. That's where a person will be, will be told of the charges against him or her. That's where a person will be read the rights, that you've got a right to get a lawyer of your choice or conduct your own defense, or a lawyer will be provided you by the state from legal aid. Those are the rights where you will be given an opportunity to plead to the charges. Charges will be preferred against you, and the magistrate will ask you as to how do you plead. It's either you plead guilty or not guilty. That is done where only it is done at the district court. Please do not say for a serious case or for a constitutional matter, for instance, where people searched your house without a warrant, then that case must start at constitutional court. There is no such thing. All those cases will start at the district court. That is very important. I've heard people telling me that certain cases, because it's a serious case or premeditated murder, and then that case must start at high court. There is no such thing. It has to start where? It has to start at the district court. And what happens after? And thereafter, if the case is too serious, that's where you will have an indictment. That's where the prosecutor, the director of public prosecution, will prepare an indictment. An indictment that will contain all the essential elements of the crime, the name and the charges, the number of charges that a person has to face. They will be contained in that indictment. Same thing applies with the charge sheet. Also, it will have your name, it will have the charges that have been preferred against you. If you are charged with theft of motor vehicle, housebreaking, so there will be count 1, count 2, count 3 of all the crimes or offenses that we have committed will appear in that charge sheet. Okay, then you will be allowed to plead. So remember section 106 of the Criminal Procedure Act, where it deals with pleas, right? That person can plead in different ways. Without pleading guilty or not guilty, you can also plead that you've already been charged with that offense, or you can plead that this thing is defective. So it is important to look at section 106. Okay, right. I have spoken of the, I must not forget this, I have spoken of the Child Justice Act, that is Act 75 of 2008. The most important sections is 15, 21, and 25. You must read 21 to 25. What does it contain? 15 will tell you about the juveniles in conflict with the law. So you must be able to know exactly what transpires when a juvenile is in conflict with the law. That is very important, right? You need also to read the historical background of Section 15 of the Juvenile Justice Act 2015. You must also read that, because if you read that Section 15 of the Juvenile Justice Act 2015, it's also very important, because it will tell you of preliminary assessment, inquiry for preliminary assessment, and then assistance of psychologists, and also period of assessment. If you read Section 4 of that act, which act is this? This is the Juvenile Justice Act of 2015, right? And then you look at Section 15 of that act. Okay, now let us make that distinction. I've told you of Section 15, and I've also told you of Section 21 up to 25. That deals with the release of a child offender before his first appearance in court. So you must be able to make that distinction. So, and also the Section 15 of the Juvenile Justice Act will tell you at Section 4, that is subsection 4 of Section 15. It will tell you of the conditions for passing an order under Section 15 of the Juvenile Justice Act 2015. The Juvenile Justice Board, you talk of what happens when a person a juvenile has committed a heinous offense, and the age group, which is between 16 to 18, right? The capacity of a juvenile to commit an offense, it's all in there. So you've got to read. It is very important for you guys to read that act, especially Section 15, because it deals with what happens when a juvenile offender is brought to court. Also, the most important case that you need to read is a case of Barun Chandra Thakur versus Master Bolu 2022, right? Read the first of the case, the order of the court, and also read a case of Shilpa Mittal versus State of NCT of Delhi. These are all Indian cases, but they are relevant to our law. You must read those cases. Also, under that law, you must read the violation of right to equality. Okay. Now we are protecting the interest of the juvenile, because you will find that our law has always to be subjected to the provisions of the Constitution. Once any law is is violating the Constitution, then that law should not be followed, because it is unconstitutional. Okay, now let us deal with what happens now when we've got our indictment and the person is brought to court. Okay, let's say our charge sheet. We will look at Section 80. Section 80 gives the accused a right to do what? To inspect. A right to inspect the charge sheet. So an accused must be given a right to inspect the charge sheet. Those are the provisions of Section 80 of the Criminal Procedure Act, right? Criminal Procedure Act is Act 51 of 1977. Do not forget that. Don't just say Criminal Procedure Act. You must, when you are answering your exams, you have to say Criminal Procedure Act 51 of 1977. Okay, right, let's continue. And then let us look at also Section 81 of the Criminal Procedure Act. Section 81 deals with what is called the joinder of charges, right? Joinder of charges. So we know exactly what we mean by a joint of charges. If the person is charged for having committed so many cases, then they are joined in that case, as long as the jurisdiction is the same. The charges will be enjoined. Okay, let me again take that small break, and then we will continue with section 82 of the criminal procedure.